Basically, I salute you all. Thanks for being on. So basically, today's topic under the law of evidence, we are looking at admissibility, all the aspects of what? Of res gestae, all the different circumstances. How can the different circumstances be admitted? Or how can they be admissible in the law of evidence or in the courts of what? Of evidence. So these are the different aspects that we are going to look at. Aspects of res gestae, and probably they cannot from section 5 to section 15 of the Evidence Act. That's where we find these different what? Aspects that make facts that are irrelevant, but once they form part of the same transaction, they become relevant. You get? And the good section, or the section that lays the foundation of the rest of the section, it is section 5 of the Evidence Act. Section 5 of the Evidence Act gives the genesis of these aspects. So basically under section 5, they say that section 5 portrays that anything that forms part of the same transaction, or anything that forms part of the same transaction in the law of evidence to the fact in issue is what? Is relevant and admissible in the courts of what? In the courts of judicature, or in the courts of what? Of law. Remember hereby, realize that at first this fact may be taken to be irrelevant, but once it forms part of the same transaction as in the fact in issue, it becomes relevant for the courts to come to their what? To their judgment. Whereby also this section connotes that whether they occur at the same time or in the same place or different places and times, so long as it is forming in the same what? Transaction, is relevant. That's section 5. And the good case, there is a case of Ara versus Kunji. This case of Ara versus Kunji, we realized that the accused person had stabbed the brother of the deceased. Had stabbed the brother of the what? Of the deceased. And had uttered, actually here they say that he had uttered what? He had uttered dangerous words to the what? To the deceased. You get? So the fact that when this accused person, here the brother of the accused or this accused person was found holding what? A knife or a dagger, a knife. And where he was coming from, that's where they found a dead body of the what? Of the deceased. You get? So in this essence here is that this accused person was in interlocks with the brother of the what? Of the deceased. Later on, he was also seen in argument with the deceased person. Then actually, you find that these facts, they are forming part of the same transaction until the murder of the what? Of the deceased. So the accused person, they held that the facts were what? Were relevant because they portrayed various aspects to the fact in issue. The fact in issue, which was what? Murder. So basically, also that have that in mind, whereby that case laid down that principle that was laid in section what? Section 5 of the Evidence Act, whereby they say that in any provision, any facts constituting to the same transaction can only be introduced for purposes of explaining the fact in what? The fact in issue. That is to deal with section 5. And section 5, the one that drives the whole what? The whole concept of res gestae. So when we go to section 6 that provides for the facts that which are the occasion or cause or effect of the fact in what? In issue. What do they mean, occasion, effect, or cause? Here we are looking at facts that, if, take for instance, the fact in issue is what? Is murder. We get, if the fact in issue is murder, then we are looking for a case whereby, or we are looking at the fact that could have caused that what? That murder. You get? And the effect, we are looking at that relevant fact, or that fact that can be presumed that is relevant after You get, after the commissioning of the fact in what? In the issue, which is what? The fact in issue, which is murder. Here we are looking to any cause, to the cause of the fact in issue. Then we also in the same section can note that the effect of the fact in issue. All those facts are what? Are relevant. You get. The good case there is the case of McKinney versus R, whereby McKinney versus R, this was a good case, whereby we realized that under the case of McKinney, here the accused person was what? Was charged of murder. You understand? For caning what? For caning a boy. But however, the boy had a disease called what? Epileptic. This disease of epileptic, realized that this disease, as a result of overcaning, the boy got shock and consequently what? Died. The accused person appealed, claiming that for his beating or the caning of the child, it wasn't the cause of the what? Of the death of the boy. But however, the court held that if he had not beaten the child or the boy wouldn't have got that disease. But it was out of the beatings that brought the disease, which the disease consequently led to the what? To the death of the what? Of the boy. Then there we are looking at the what? The effect. So those facts are relevant because they stand in line to the cause of the fact in what? In the issue. So basically that is to deal with section 6. Okay, facts as to the occasion, cause or effect to the fact in what? In the issue. Then when you go ahead, we have what they call section, what they call motive, preparation, and previous or subsequent what? Conduct. That is section 7 of the Evidence Act. When you read to section 7, for it provides that any fact, you get, any fact that provides for, that shows motive or shows preparations, previous or subsequent what? Conduct, they are all relevant and admissible. You get, what do they mean basically here in this essence? Here what they mean, or probably what they are reflecting at, is that you must show that these facts show motive. That if I murdered someone, these facts show the motive. You get, as we shall see. If I murdered someone, these facts show preparations. That I did like this so that I can do the what? I can murder someone. Previous, I did this before the commission of the what? Of the fact in issue. Subsequent, maybe if after murdering I ran away, that is a subsequent conduct that is also relevant, because nobody that is innocent can run away. Just somebody who is a guilt conscious is the one that what? Can run away. And basically, section 7 provides for that. The motive, preparation, previous and subsequent what? Conduct to the same. And here, basically what you have to know or what you have to bear in mind is that a conduct of any person to an offense against whom it is subsequent of any proceeding, whether civil or criminal, is relevant if that conduct influences or is influenced by any fact in the issue or relevant fact. You get? So basically note that in mind, basically, when you are dealing about someone is what? Conduct. And for you, what you have to know about motive. Motive is like what influences a person to act in a particular way. You get? That is to deal with what? Motive. Something that influences a person to act in a particular way. That is to deal with what? Motive. And basically under criminal law, since evidence is composed for both civil and criminal, and basically under criminal law, motive is basically, they say that some a certain extent, sometimes for them to prove motive is what? Is irrelevant. But under the courts of what? All the different laws. So as I was saying that under criminal, motive is what? Is relevant. but it is relevant under the law of evidence once it can bring out a particular element of what? Causation. You get? If the motive points to the facts that this is what inspired you or what caused you to do the fact in what? In issue, then it becomes what? Relevant under criminal law. That's the difference that I was talking about. And basically also, for a good definition to bring out the concept of motive, they say that motive may be a fear or a desire to bring out a particular what? Activity. It may be a fear or a desire. So long as there is that concept of what? Causation, it becomes relevant. You get? And there is also a good definition also which talks about that motive is a mental state, and it's normally derived from circumstances and relationships. And basically, note that in mind about motive. When you read section 7 clause 2, section 7 subsection 2, of the Evidence Act provides for that. And there is what they call preparation. Preparation, basically here we are looking at the things that you do prior to the commissioning of the what? Of the fact in issue. If it is murder, they look at the things that you do prior to the commissioning of what? Of murder. For example, I'll use the good example. For example, if the facts show that you went to a shop and bought pangas, you bought knives, you bought masks, you get, and the murder that was committed, it was committed using pangas, the person that committed had a mask. So the fact that you went to the shop prior to the commissioning of the crime shows that you are bought for the what? You bought those equipments that you used during the commissioning of the what? Of the offense. Then that is preparation. That's what they call preparation. And what you have to know about here, or what you have to put in mind about preparation, is the fact that here we are looking all these, okay, so this element, all the elements of all the aspects of res gestae, what you have to put in mind is that you're already being accused. You're already being accused, but the prosecution is looking for how it can make you what? Guilty. You're already being accused of murder, but how can the prosecution prove beyond doubt for you to be what? Convicted. You get? That's why they are bringing in these aspects to make you what? Liable, or to make you what? Convicted. So that's what we can say about what? Preparation. And the good definition about preparation is that preparation actually may refer to any particular what? Any particular prerequisite, or it is a prerequisite. Basically, it is a prerequisite to bring about a particular fact in what? In issue. You get? So that's what they call preparation or preparation. Section 7 still talks about what? That. And here what you have to bear in mind, or what you have to put in mind, is that preparation can be used by the prosecution to convict the what? The accused person. Then we also look at what they call what? The previous and subsequent what? Conduct. What do they mean by the previous and subsequent conduct? For the previous is something that happened prior. Then subsequent is something that happens after the fact in issue. If it is murder, after the murder, that is subsequent. But for previous, it comes before the murder took place. You get? So basically, there is a case of Uganda versus Barikunda, son of Rwanda. The case of Uganda versus Barikunda, son of Rwanda, here realized that it was determining the intention, what we call the motive. You get? It was talking about the motive. And here they say that the accused and the deceased had what? A dispute. You get? Over land, of which the dispute was was what was resolved in favor of the deceased. So here, by his father and the local what, and the local committee, here now the accused then threatened the deceased that he will never use that land in peace. Again, so they came and both went for drinking together. When they went for drinking together, in fact their home was nearby. The other ones lived, the home was like a few miles from the other. So they are like neighborhood, but there was a some distance. So when they went to drink, the quarrel erupted from where they had went to drink from. Then after the quarrel had also occurred there, they went back home. Then the deceased passed via the accused's house. They again started quarreling again. And the accused person chased the deceased with the knife and stabbed him on the stomach, and the intestines come out. Which later led to his death. The accused person then later ran to the hills, where he hid until he was arrested. So this case shows that there was motive, something that caused someone to commit the murder. It was a land issue. It shows the subsequent conduct. The subsequent conduct is where the accused ran up hills. You get? So that is a very, very good case on Section 7 of the Evidence Act. Also, that case of Uganda versus Barikunda versus son of Revanda. Then there is a case of Robo versus R. The case of Robo versus R is on the previous conduct. And under that case, court had something to say or had something to lament, is that it said that for previous and subsequent conduct in cases of rape and allied offences was discussed. Court held that the complaints of such victims of such offences, if made at the first reasonable time after the offence, are admissible. You get? So the court was lamenting on on how it can admit such evidence. So basically that is the essence. And there is also the case of Uganda versus Simon Onen. The case of Uganda versus Simon Onen, here you see that the accused person was charged of murder. Basically, they found a dead body just a few miles from his home, and it proved that it had been dragged from the accused's home. And here the accused disappeared for 2 months. And on coming back, he said that he had feared. He was afraid for the local military or the mob justice from the community, that they would kill him. But however, court held that the conduct of running away was not that of an innocent man. You get? When you read the case of Henry Chifamunte versus Uganda, their court accepted the appeal that it was that of an innocent man, because he ran in protection of his life, but he was innocent. And also there is a case of Ara versus Ball, still in line with Section 7. You get? There are many cases, but what you have to bear in mind is that to understand the concept, what does that principle or that aspect mean? So when we go to Section 8 of the Evidence Act, which provides for explanatory and introductory facts, you get, provides for that. It introduces that anything that explains or introduces a fact in issue, you get, it is irrelevant. Anything that explains explains or introduces those facts, it is relevant. Why do I mean? Here, basically what they mean is, it can mean anything that can explain, anything that can support or rebut an interference anything that establishes identity or that identifies a fact in issue, all those facts are what? Are relevant and admissible. And here basically what you have to bear in mind, as in where I said that any fact that supports or rebutes an interference, it falls under Section 8 of the Evidence Act. What do I mean? Here I can give an example. If a crime is committed in a room and the only person with the keys is inferred that he or she is what? Is guilty. You get? Take for instance is that if at all they break a room, you get? If at all they break a room, but here realize that evidence may say that the one that had keys is the one that what? Stole the things that were in the room. But however, if the one that had keys comes out and says that, by the time they broke, I was in Kenya, which means those are facts that are rebuting the interference, that rebut the interference, or that support the interference. Basically, that is what I'm trying to mean in the facts that support or rebut. So, and when you combine Section 8 and 10, both review the facts that are inconsistent with any fact in issue, with relevant facts. You get? Also, when you relate to the case of Francis Kayemba versus Uganda, the case of Francis Kayemba versus Uganda, here the appellant was charged of theft, mainly based on circumstantial evidence. But before his conviction, the case before his conviction, they held that the court must first find in the interlocutory statements or facts, or the interlocutory facts that are incompatible with the explanation and another reason that the guilt is not there or is there. You get? So basically here they lament that it is necessary or it is crucial for the courts to draw the interview before them drawing the interference of guilt or drawing on the circumstantial evidence, to be sure that there was no coexisting facts which would weaken or destroy the interference. So before courts making the judgment must first be certain. You get? They must first be certain to the fact. And basically there what you have to know or what you have to bear in mind is that Section 8 also connotes to the identity. You get? Here the identity or identifying the fact in issue. Basically here it may be identification, single identification witness, among others. And the identification basically is an expression of opinion that a thing or a person resembles another thing or person, in fact, in the issue. You get? That's to deal with identification, basically. So any fact that brings out identification is is relevant. You get? And the following must be considered under identification, or under identifying, or under a single identification witness. Basically one of it is that the identification witness must have observed the accused. The identifying person must have had a settled impression in his or her mind. There's nothing like having a second thought. The mental picture that a person has at the time of identification. Someone might be sane, not insane. And the time taken in identifying is also key. Was it nighttime or daytime? If it was night, which source of light was there for someone to be identified? And there must be also an opportunity allowing for proper identification. Basically it can be proper opportunities that you had the guts, maybe the position that you are in, you had the opportunity to get a proper view on what you are identifying at this time. And also the coincidence between the person identifying and the person being identified. It is also key. Some people may have different grudges, or they may have different beef, and says that I saw this one, yet there was what? There was a beef or misunderstanding between them. So that is also key. It is also key for court to consider, so that they can accept what? The evidence for someone identifying what? Another person. So when you read the case of Musoke versus R under identification, for it, actually this case, it established the practice to a question, to a witness as his or reasons. The identification must actually the question put ahead, it must, the witness's identification must not have been influenced by any persons, you get, and there must not be any reasons for her doing so. It must be an honest belief of what? Of the law, and it must be voluntarily what? Made, you get. And actually under identification, it is not a question and answer, you get. It is basically a description that an identifying witness gives, but basically it is not what? A question and answer mode. That's what the case of Musoke versus R connotes. So basically that's what I can talk about that section 8. And with the case of Uganda versus Intervals, this one is on the single identification. Basically here deals with identification what? Parade, but we shall explain more and more under what? A single identifying what? Witness, under the procedures of conducting what? An identification parade. But for now, we are just talking about how it can be admissible for the moment. And here basically what you have to bear in mind is that even section 8 talks that the fact that also fixed time and places at which the relevant issue happened, they are what? They are relevant. And also the relationship of parties, they also put that in what? In place. But we shall continue to see that in a topic of its own. You get? So that is section 8. So when we go further under the aspects of res gestae, realize that there is also section 9 of the Evidence Act, facts that show common intention. What do we mean by common intention? Common intention may all mean by as conspiracy, anything whereby two persons conspire together and commit what? An offense, or anything said or done. So basically here brings that element of what? Common intention, you get, and it is relevant. Any facts that show common intention. Common intention can be that maybe you knew about the commission. We all know that we have started under parties to a crime. So those parties to a crime, the element that can normally be proved is that element of common intention. For him or her to be what? A party to a crime. You better either among others. So bear that in mind, or have that in mind, that anything that talks about common intention, only any fact that shows that you really knew of what the fact in issue, if at all is theft, you are also what? The facts are relevant for your conviction, you get. And also bear in mind as you are reading these concepts, bear in mind here that the accused person is what? Is accused and is in the courts of law, but you are standing as a prosecution to make him what? Guilty, you get. So under common intention, there is a case of Barricade versus Uganda, where a court held that for it, in order to prove what? Common intention, it's not necessary to prove it to prove a prior agreement between the accused. It is sufficient if their intention could be inferred from their what? Actions. You get. Common intention could be inferred from the presence of the accused, the actions of the accused, the omission to dissociate himself from the attack, among others. You get. That's why you must look at the concepts of what? The parties to a crime. It brings out that key very, very good. Then when you go to Section 10 of the Evidence Act, Section 10 of the Evidence Act, for it talks about the contradictory and inconsistent facts. Any facts that contradicts or brings out that consistent element to the fact in issue is relevant and admissible. You get? That's why they say that facts not otherwise relevant are relevant if they are inconsistent, or if themselves or are in connection with other facts, they make the existence or the non-existence of any fact in issue, they are highly admissible. You get? And for Section 10 that I've speculated, for it provides that negative element in the facts which negate or affect the improbability of any fact or issue. You get? Becomes relevant. You get? And for inconsistency or any facts that bring inconsistent is that if at all you have a certain class of evidence, then someone comes and gives other evidence that is contradicting with what you already have, that fact is relevant and removes the previous evidence that you did you had. You get? So those things are relevant. For example, there is a case of Uganda versus this man, Sabuni. Under this case, it established the law in Uganda that when an accused person sets up the defense of alibi, the accused does not assume the responsibility of proving the alibi. The onus is on the prosecution to do to make the alibi defense negative before the evidence that is brought. So the evidence that is put forward by calling witnesses to rebut, you understand, or to contradict with the defense of to bring contradiction with the evidence of the or with the defense of the of the accused person. You get? So basically note that in mind. And there is a case of Uganda versus Ludovico Kaija. The case of Ludovico Kaija realized that it was under a dying declaration, as you shall see there, under a dying declaration means there, whereby under here the accused person was indicted for murder. You get? And the accused and the deceased were renowned enemies for a long time. So the deceased was lying in the footpath and with the fatal wounds, whereby he made an alarm and people ran after him, whereby even the accused person ran also. And on that same day, the accused pointed to the Pointed to the accused. The deceased, before dying, pointed to the To the accused. Even when he was also in the hospital, he also pointed to the